Edward Douglas White was an American politician and jurist, was a United States Senator, Associate Justice of the United States Supreme Court, and the ninth Chief Justice of the United States. He was best known for formulating the rule of reason standard of antitrust law. Landmark cases he was involved with was his side with the Supreme Court majority in 1896 decision of Plessy v. Ferguson, a case which upheld the legality of segregation in the United States under the separate but equal doctrine. However, in 1915, White wrote for an unanimous court in Gwynn v. United States, which struck down many Southern states' grandfather clauses that disenfranchised African Americans. Edward Douglas White was born and raised in La Fourche Parish, Louisiana, on November 3, 1845. His father was Edward Douglas White Sr., who was a judge, a U.S. congressman for the Whig Party, and the 10th Louisiana governor. His mother was Catherine Ringgold. White first studied at a Jesuit college in New Orleans. He then attended Mount St. Mary's College, a Jesuit preparatory school. White then attended Georgetown College, where he was a member of the Philodemic Society. While attending Georgetown, his studies were interrupted by the American Civil War. White returned home to join the Confederate Army. After the war, White resumed his studies at the University of Louisiana, where he studied law. He was admitted to the bar in 1866 and established a law practice in New Orleans. White was elected to Louisiana State Senate in 1874. From 1878 to 1880, he served on the Louisiana Supreme Court. In 1891, the state legislature elected him to the United States Senate. President Grover Cleveland nominated White to the Supreme Court of the United States on February 19, 1894. The same year, White married Virginia Montgomery Kent. White had served for 16 years on the court when on December 12, 1910, President William H. Taft nominated him Chief Justice of the United States. His greatest contribution to the United States jurisprudence was his rule of reason decision in 1911 that federal courts have since applied to antitrust cases. In the 1911 decision to break up the Standard Oil monopoly, White wrote the majority opinion, which held that all monopolies were not illegal. The role of the court, however, was to restrict only those monopolies which, in the court's opinion, were unreasonable or which conspired to restrain trade. He was admired for his warmth and approachability. He worked hard to bring about reconciliation within the court, and he used his position to help reconcile post-Civil War North and South. In 1915, White succeeded in obtaining unanimous support for striking down the grandfather clauses, which violated the 15th Amendment by preventing many African Americans from voting. White's sense of patriotism led him to support the federal government on the issues of the national draft when the U.S. entered World War I. In opposition to his usual stance of trying to prevent the expansion of the federal government's powers.
Snyder v. Phelps Supreme Court case. Fred Waldron Phelps was a minister for the Westboro Baptist Church and a civil rights attorney. He had extreme religious views on homosexuality, and he was notorious for this. He led protests around funerals for gay people, military veterans, and disaster victims. Matthew Snyder was a U.S. Marine Lance Corporal and was killed in Afghanistan during his service. He did not die in combat, but in a vehicle accident. His father, Albert Snyder, is the plaintiff of this case, and sued Fred Phelps, the Westboro Baptist Church, and two of Phelps' daughters, Rebecca Phelps Davis and Shirley Phelps Roper. The background of this case began in March of 2006 at the funeral of Matthew Snyder. Phelps and the members of the Westboro Baptist Church were picketing at the funeral. They did this on public land close to the place of the funeral and were compliant with the authorities who were involved. This is important to the decision of the case. During the funeral, Albert and the Snyder family could not see the protesters, and it wasn't until the event was on the news when they saw what the people were saying. Albert Snyder sued Fred Phelps, the Westboro Baptist Church, and two of Phelps' daughters, Rebecca Phelps Davis and Shirley Phelps Roper, because of the severe emotional stress the event caused on him and his family. Albert Snyder, the plaintiff's hearing, was on October 31, 2007. the jury found for the plaintiff and awarded Snyder $2.9 million in compensatory damages, later adding a decision to award $6 million in punitive damages for invasion of privacy and an additional $2 million for causing emotional distress. This came out to be $10.9 million, which was later settled at $5 million to accommodate for the Westboro Baptist Church's ability to pay. This verdict and awarded money wouldn't last, though. On September 24, 2009, the defendant, Fred Phelps, had his appeal in which the Fourth Circuit Court of Appeals reversed the verdict and got rid of the $5 million awarded to Snyder. Phelps's actions were protected by the free speech clause of the First Amendment to the Constitution, which was enough to win him the case. Albert Snyder was to pay the court fees for the defendants, which came out to over $16,000, but this was paid for by supporting people all over America. The case ended in an 8-1 decision in favor of Phelps, and the Supreme Court decided this way to uphold the integrity of the First Amendment. The majority opinion was written by Chief Justice John Roberts, stating what Westboro said in the whole context of how and where it chose to say it is entitled to special protection under the First Amendment, and that protection cannot be overcome by a jury finding that the picketing was outrageous. Justice Stephen Breyer wrote a concurring opinion emphasizing his view that the decision related only to picketing and did not take into any consideration Westboro Baptist Church's online publications that attacked the Snyder family. Justice Samuel Alito wrote the dissenting opinion, which stated, "Our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case. In order to have a society in which public issues can be openly and vigorously debated, it is not necessary to allow the brutalization of innocent victims like petitioner."